हेलो हेलो। हेलो सर, मेरी आवाज आ रही है? हाँ जी सर, चालू हो गया है सर। सर ये कह रहा था कि इसमें जो है ना, जो फोटो दिख रही है सेमिनार हॉल की, वही सर पिन करना है सर। और हाँ सर, और सर इसमें एक चीज और है सर। इसमें जैसे कुछ नहीं, वो लोग ज्वाइन करने के बोलते हैं अलाउ अलाउ, तो वो सर राम सर ने जैसे कहा था वैसे कर देना। बीच में यहाँ डिस्टर्बेंस होता है राम सर, वो है ना सर, बोलते हैं ये क्यों आ रहा है, वो सर और कर दीजिए सर। जैसे नहीं वो पार्टिसिप और सर जो है ना अलाउ करते हैं ना, एडमिट एडमिट करके जो कैंडिडेट आते हैं जुड़ते हैं, तो उसमें सर यहाँ बीप आती है, तो बार बार डिस्टर्बेंस होता है, तो वो थोड़ा सा कर दीजिए। हाँ जैसे अभी आ गया है, देखिए। जी सर प्लीज। ओके सर। नहीं, अभी तो सेमिनार हॉल में चल रहा है सर, ड्यूटी सेशन है। जी सर।
बीए एलएलबी बी सेक्शन है बीए एलएलबी बी किसे सारे सेक्शन दिखा है और सेक्शन ए अब बीबी एलएलबी बीएलएलबी चलेंगे स्टार्ट कराएं बोला
चलिए ये वाला
ड्राइंग
Good afternoon, ladies and gentlemen. With great joy and a sense of accomplishment, we welcome you all to the valedictory session of the National Workshop on Intellectual Property Rights, Challenges and Opportunities. We are privileged to extend our cordial felicitations to the Honorable Pro-Chancellor and Senior Vice President, Ratan Balved Education Foundation, Lieutenant General P.K. Sharma, Honorable Vice Chancellor, Amit University, Madhya Pradesh, Professor Dr. R.S. Tomar, esteemed Speaker, Dr. Sandeep Singhai, Principal Scientist, AMPRI, CSIR, Bhopal. We also extend cordial felicitations to Professor Dr. M.P. Kaushik, Honorable Pro Vice Chancellor Research, Amit University, Madhya Pradesh. The convener, Professor Dr. Pankaj Mishra, and co-convener, Professor Dr. Swapnil Rai, deans, directors, HOIs, HODs, faculty members, research scholars, and participants who have joined us online. Dr. Rishi Sharma, Principal Scientist, CERI, Pilani, will be joining us shortly. This workshop has indeed been a fruitful journey of ideas, knowledge, exchange, and meaningful deliberations. And now we bring it to a dignifying close with today's valedictory session. Before proceeding further, we are privileged to extend a warm welcome to our esteemed guest speaker on this valedictory session. We feel honored to welcome Dr. Sandeep Singhai, Principal Scientist, AMPRI, CSIR Bhopal, a distinguished expert in the field. We request the Honorable Pro Vice Chancellor. Thank you, sir, for joining us. To begin the proceedings, we are privileged to have with us Dr. Sandeep Singhai. It is my privilege to introduce our eminent speaker to the audience. Dr. Singhai is a PhD in engineering with specialization in technology management and has over 2 decades of experience in research and research management. Earlier, he served as Head of Business Development and IP Coordinator at CSIR Chandigarh, where he worked extensively on embedded systems for strategic applications, technology management, and IT. Sir has played a pioneering role in the development of head-up displays for indigenous aircraft such as Tejas Nehru, and Hindustan Jet Trainer, a contribution that earned his team the prestigious recognition of most important technology of CSIR in 5 years. A fellow of IETE, a fellow of WIPO-PTP, and a senior member of the Computer Society of India, Dr. Singhai has to his credit numerous research publications, popular science writings, patents, and has earned a reputation as a dynamic speaker and motivator. With such remarkable achievements, we are truly honored to have him with us today. So please join me, all of you, join me in welcoming Dr. Sandeep Singhai. So please, you're requested to kindly be recognized.
So, respected dignitaries on the dais, participants of the dais, and my dear students. Talking in a valedictory section, and that too after lunch, is always difficult because your audience, some are blinking their eyes, some are somehow managing to sit straight, and I don't know how much of you have or have not had lunch. But I will try to make the subject of IP a bit interesting. I'm sure you have been hearing to the IP topic since last 2 days, or you are here for the first time among the students. So first time, good. So I'm fortunate in that sense that whatever I will be speaking is not a repetition for at least majority of my audience. So I thank the dais and the dignitaries for inviting me. And today I will be talking about IPR, opportunities and challenges. As I came to know about the topic, and speaking at various platforms is my passion. I in fact got a call a few days ago from Dr. Mishra, and I thought, why not? After coming to Madhya Pradesh around 3 years, I have visited around 40-50 institutions in these 3 years. So with this, I will try to take you to a level as far as IP is concerned, that whenever in life you want to do something in this field, you have that background knowledge. That will be my main target, right? So this is I'm representing CSIR, my salary giver. आज ही आया है. In government, last day of the month you get the salary. So it has a pan-India presence. CSIR has 38 laboratories in its umbrella. The youngest one is CSIR 4PI, Fourth Paradigm Institute, which basically works on what most of you are doing these days about cloud and modeling and all those things. And then we have each and every city in Bhopal, in Madhya Pradesh, we have only one. It was previously known as RRL, Regional Research Laboratory. 2007, looking into the way in the areas it is working, it was renamed to Advanced Materials and Processes Research Institute. So this institute basically works in new materials as well as turning waste into wealth. Whatever huge industrial waste are there, which are hazardous in nature, which can't be used by anybody, we use them for some certain applications which are useful in civilian fields as well as strategic fields. One of the earliest innovations I did was whenever you go to vote, the ink which is placed on your finger that ensures that you don't reach again to vote, that indelible ink was developed by CSIR way back. Still today, it is being sold by Masur Paints, and it is through an RDC. There is one company called National Research Development Corporation, which was basically formed to ensure that technologies of the government institutions are marketed. So that particular company still gets the royalty for that thing, and through that CSIR gets it. We are a niche in laboratory working in the field of engineering materials with a focus on new materials and waste to earth. Roughly, we have 50 to 52 scientists, and we publish more than 100 plus SCI publications. Recently, we have come up with very good infrastructure. It's in fact the first 5-star rated green building of Madhya Pradesh. And industry interactions, we have a lot of TOTs, NDAs, MOUs, and various things. 10% of our scientists, roughly 5 are in that 2% Stanford list. We also have 2 programs which are of interest to students and research scholars. One is the skill development program, through which all our facilities, all our skills are available for training. And secondly, we have the centralized testing facilities, through which all our instrument facilities are available for research. In fact, CSIR also has an MOU with Amity University, which was held in 2019, and it is due for renewal in 3rd of September 2024. There is a meeting between our DG and Silvamurthy Saab in Delhi. So in that way, we are also available through an institutional arrangement for whatever needs you have. I will skip it. Before going on to IP strictly, one more thing, which because students are here, I love to talk about sustainability. व्हाट इज सस्टेनेबिलिटी? आप सबने काफी सुना होगा, आई थिंक स्कूल्स में भी पढ़ा होगा, आपके टाइम तक स्कूल कोर्सेज में भी सस्टेनेबिलिटी, सस्टेनेबल डेवलपमेंट गोल्स आ गए होंगे, एसडीजीज, राइट? सो सस्टेनेबिलिटी इज नथिंग बट टू लीव द वर्ल्ड एज वी गॉट इट, so that our children and grandchildren are able to live a life free of mask and other things, obviously. So the situation is alarming, and आजकल हम बारिश हो रही है, बहुत सुन रहे हैं ना, पहाड़ गिर गया, ये बादल फट गया. So that situation क्यों है? क्योंकि 1850s में जो अर्थ का एवरेज टेम्परेचर था, that was around 13.5 डिग्री. How much? 13.5 डिग्री. राइट नाउ वो लगभग 1.5 डिग्री बढ़ चुका है, 15 डिग्री तक पहुंच चुका है. But the moment it crosses 2 degrees, the average temperature of the earth crosses 2 degrees, आप इसको ऐसे ही ले लीजिए, आपका बॉडी का टेम्परेचर 97.4 कुछ फ़ारेनहाइट, राइट, या 6 फ़ारेनहाइट, वो मान लो 102 डिग्री हो जाए फ़ारेनहाइट में, तो कितना हालत बॉडी का जो है डिटेरियोरेट हो जाता है. एंड उसके बाद इसके बियॉन्ड आप जाओगे तो सेल्स आपके मरने लगेंगे और आपकी बॉडी में इररिपरेबल चेंजेस हो जाएंगे. Same is the case with the earth. Once that average temperature crosses 2 degree, it will be the major permanent changes will occur in the environment, and which will be irreversible, even if you regain the conditions which were earlier. So you all should be serious about it. And in fact, for researchers right now, in research also, whatever funds come, government has certain compliance requirements as far as SDGs. वर्ल्ड लेवल पे गवर्नमेंट को सस्टेनेबल डेवलपमेंट गोल्स का या नेट जीरो एमिशंस का बहुत सारा कंप्लायंस रिक्वायरमेंट्स है. सो नेचुरली ऑल द गवर्नमेंट्स अराउंड द वर्ल्ड आर पंपिंग मनी इनटू एरियाज व्हिच हेल्प देम और लीड देम टुवर्ड्स अचीविंग दोस गोल्स. सो रिसर्च में आपको पैसा भी काफी मिलेगा यदि आप इस फील्ड में काम करेंगे, और साथ में आप उसमें पर्सनल लेवल पे भी यू शुड बी सेंसिबल एंड सेंसिटिव अबाउट दीज थिंग्स. अब आईपी के बारे में आप लोग क्या जानते हैं? थोड़ा बहुत जानते हैं? व्हाट इज इंटेलेक्चुअल प्रॉपर्टी? व्हाट इज प्रॉपर्टी? घर, गाड़ी, बंगला, सब इसीलिए पढ़ रहे हो, यही सपना है ना? सो इंटेलेक्चुअल प्रॉपर्टी इज बेसिकली क्रिएशंस ऑफ ह्यूमन माइंड. आप ह्यूमन माइंड का यूज करके जो भी यूजिंग द कॉमन्स अवेलेबल इन द नेचर, जो भी नेचर में अवेलेबल कॉमन्स हैं, उनको यूज करके आप कुछ भी नया बनाते हो, which other people have not done so far, that becomes your IP. सबसे आसान एग्जांपल आपके नोट्स, जो आप बड़े आगे एग्जाम तक रखते हो, कोई बाजू वाला ना देख ले भाई, बिकॉज यदि देख लेगा तो वो सेम सा आंसर लिख देगा और जो आपका एक क्रिएटिव एज है या जो एडवांटेज है वो खत्म हो सकता है. नाउ दिस इज IP, राइट? IPR is basically a handshake. How? Because if we talk about IP, it used to happen, हम पढ़ते थे ना कि एक पुड़िया दी उन्होंने और पुड़िया की इससे हमने दवाई खाई और ठीक हो गए. Now he is not disclosing कि उस पुड़िया में क्या है. क्यों नहीं डिस्क्लोज कर रहा? क्योंकि यदि किसी को पता चल गया तो वो फॉर्मूला कॉपी कर लेगा और मेरा काम खत्म. सो अब गवर्नमेंट ने एक मैकेनिज्म बना दिया IPR, इंटेलेक्चुअल प्रॉपर्टी राइट्स का. उसको उन्होंने एक हैंडशेक बनाया कि भाई आप सब कुछ बता दो, उसके बदले हम क्या दे देंगे आपको? लिमिटेड पीरियड का मोनोपोली दे देंगे. क्या दे देंगे? लिमिटेड पीरियड का मोनोपोली दे देंगे. उसमें आप जो कमा सकते हो कमा लो. एंड देन पब्लिक का क्या फायदा है? हम कह रहे हैं हैंडशेक है तो पब्लिक को भी कोई फायदा होना चाहिए. सो द पब्लिक इज बेनिफिटेड बाय, बिकॉज वंस दैट IP राइट का जो मोनोपोली पीरियड खत्म हो गया, उसके बाद that knowledge comes into the public pool. That knowledge comes into the public pool. आप कल के दिन कोई IP लेंगे भी तो उसमें आपको नोवेल्टी कैसी चाहिए? ग्लोबल चाहिए. राइट लोकल मिलेगा, जिस कंट्री में आप पेटेंट ले रहे हो राइट वहीं का मिलेगा. बट ये नहीं कि इंडिया में आज तक किसी ने नहीं किया, फर्स्ट टाइम इन इंडिया. दैट इज नॉट अ ग्राउंड फॉर गेटिंग ए IP. So the inventor or creator discloses the entire invention, and in turn limited monopoly is provided. अब ये लास्ट जो लाइन लिखी है इसको भी थोड़ा सा हम समझेंगे. यूज्ड एज ए स्ट्रेटेजिक टूल अंडर WTO. एग्जैक्टली मेरे पास टाइम कितना है? या फिर भी एक अंदाज. इट्स 2:52 नाउ, राइट? सो इट्स अ स्ट्रेटेजिक टूल अंडर WTO. आप सबने गेट के बारे में सुना है? जनरल एग्रीमेंट ऑन ट्रेड एंड टैरिफ. So when India became independent, अरे जोर से बताओ. And when India signed or became member of WTO, 1948. So ऐसा कहा गया कि हमें फिजिकल आजादी मिल गई, व्यापार में हम फिर से गुलाम हो गए 1948. गेट कब तक चला? आप शायद लॉ के स्टूडेंट्स हैं क्या कुछ? गेट कब तक चला? 1995 तक आई थिंक. इफेक्ट में 1995 तक रहा. And GATT was converted into WTO. WTO had how many agreements? 3. General agreement on trade, general agreement on services, and the third one was TRIPS, trade related aspects of intellectual property rights. It was for the first time in the history that IP was used as a strategic tool to have trade negotiations. IP became a part of trade negotiations. However, you all should be understanding that IP is a sovereign subject. लॉ के स्टूडेंट्स हैं तो पता ही होगा कि आईपी सोवरेन सब्जेक्ट है. बट ट्रिप्स ने सोवरेन सब्जेक्ट के उन एस्पेक्ट्स को नहीं छेड़ा which were dealing with sovereignty. Basically, TRIPS touched upon the aspects which were related to the framework, standardization of practices, standardization of processes, standardization of durations, standardization of what type of things can get what type of IP, standardization of types of IP. Still, there are certain IPs which are not available in India. Utility patents is available in India? No. It is available in Australia? Yes. So, in that sense, IP was used as a strategic tool for the first time under TRIPS. Now, innovation is very loosely used term. A lot of things we call innovation. But typically, as far as I think and so much I have read, innovation is basically something offering new in the market. आप सब दिल्ली गए होंगे. दिल्ली मेट्रो में जब टिकट के लिए जाते हैं, वहां एक बच्चे का आपने वो देखा होगा, इसमें रास्ता बना होता है बीच में से. सारा झगड़ा ही खत्म हो गया है कि बच्चे को झूठ बोलो कि 5 साल का है कि 4 साल का है. 3 फुट से बड़ा है तो टिकट लेना है, और उस होल में से निकल गया बच्चा तो टिकट नहीं लेना है. सो इट्स अ वेरी सिंपल इनोवेशन. दूसरा इनोवेशन, आप क्या मानेंगे, कैश लेना इनोवेशन है. कैश पेमेंट इज इनोवेशन. हो सकता है कैसे? उबर हम सब यूज करते हैं. बिफोर लॉन्चिंग इन इंडिया, उबर नोवेयर यूज्ड और टुक कैश पेमेंट्स. फर्स्ट it started a pilot in Hyderabad, and based on the study they found that female and elderly, two category of people, are more comfortable paying cash because of some technical problems and whatever. So after having a successful pilot, Uber implemented in lot of countries which were of the social dynamics like India, taking cash payments they started. So in terms of science and technology, innovations that are based on science and technology are usually inventions, and to protect these inventions we have IPR. So this is one domain of IPR which basically emanates as an industrial property. The second realm or second domain of IPR is creative works. So creative works are works done created by the writers or artists, artistic and literary works, and they are broadly covered by the copyrights and related rights. This is a famous picture. You should have heard about the monkey who took his own selfie. So who will own the copyright was a long question. It has been since answered. Now this particular slide is very favorite to me, which basically covers the entire universe of the IPRs. You have intangible assets. IPs are basically intangible assets, and they can be divided into two realms. One realm is where the idea itself is protected, and the second realm is where the expression of idea is protected. आइडिया प्रोटेक्शन के डोमेन की जितनी भी आईपीज हैं वो बेसिकली इंडस्ट्रियल प्रॉपर्टी के डोमेन में आती हैं, और एक्सप्रेशन ऑफ आइडिया के प्रोटेक्शन की जितनी भी, इसका एग्जांपल सिंपल है, सूरज उग रहा है, राइट? सूरज को उगते हुए देखकर जावेद साहब ने कोई अच्छी सी कविता लिखी. नाउ does Javed Saab gets the copyright of rising of sun? No, he gets the copyright of his expression or expression of the idea of rising of sun. So and related rights cover all those performers, broadcasters, blah blah blah, whatever. हिस्ट्री में यदि आप इंटरेस्टेड है थोड़ा बहुत, नहीं तो मैं स्किप कर दूंगा आपकी शक्ल देख के. यदि आप रिल्म में जाएं तो बेसिकली क्या था, पुर्तगाल में एक इंडस्ट्रियल एग्जीबिशन होने वाला था बहुत पहले. उस समय कुछ और कंट्री थी, एग्जैक्टली पुर्तगाल नहीं थी. और उस एग्जीबिशन में पूरे यूरोप की कंट्रीज को इनवाइट किया गया था, इंडस्ट्रीज को इनवाइट किया गया था अपने प्रोडक्ट्स दिखाने के लिए. दे वर स्केप्टिकल दैट ऐसा हो सकता है कि हम उस किंगडम में यदि अपने प्रोडक्ट्स ले गए तो वहां के जो लोकल्स हैं उनका डिजाइन चोरी कर लेंगे एंड अवर प्रोडक्ट विल बिकम ऑब्सोलीट और a general knowledge. So at that time that kingdom brought a special legislation. That legislation was about that in this exhibition whomsoever displays the product, it will not be, nobody will be allowed to copy it without the authorization or permission. Now as this talk emanated, it converted finally into Paris Agreement. Paris Agreement is about industrial property. It is still in force today. India is a signatory to Paris Agreement. And secondly, when printing press came in, the rights of the writers or the creative people were undermined, and then something started in Britain. The king had some law, and that finally culminated into Bonn Convention of 1886. It is also still today live. Both of them merged into International Bureau in 1893, and then WIPO came into existence in 1967. And in 1974, like UNESCO, ILU and all those, WIPO became a specialized agency of United Nations. As on date, WIPO is a specialized agency of United Nations. And then the TRIPS agreement came in, wherein these IP rights were integrated with the WTO. Now this is the panorama. I think you all may be knowing the entire panorama. ऐसा कोई है जिसको नहीं पता? आज ही मैं एक वर्ड पढ़ा था, निटे निटे, neither yes, neither nor this, neither this. So intellectual property rights, this is the panorama. You have patents, industrial property, you have trademarks, industrial property, only perpetual right. All others have a life. Industrial design, how you look something by a bare eye, that's it. Trade secret, until kept, it is an IP, it is not registered. It is again perpetual, but the day it is revealed, gone. Coca-Cola, good example. Copyrights for the expressions of ideas, geographical indications के बारे में सुना है? GI tax. GI tax basically GI दिलाने में सबसे बड़ा रोल है लिकर इंडस्ट्री का. Scotch, champagne, ये सब जो है यूरोप, but India is also using it very nicely. GI मैं आगे जो specific slide में बात करूंगा उसका. Then plant varieties protection is about new plant varieties. This is under Ministry of Agriculture in India, newer seeds and all those things. Then layout design of semiconductor integrated circuits, and then innovative and creative expressions of indigenous and local communities. ये अभी IP नहीं बनी है, TC और TCE. ये कुछ जो IPs हैं, जैसे GI इंडिया में 2001 से पहले नहीं थी. इंडिया को 10 साल मिले थे. India became compliant in 2005. Because India was a developing country. So this GI नहीं था, layout design नहीं था, इन सब के लिए नए लॉ बने, जिसको क्या sui generis बोलते हैं, क्या बोलते हैं? One of its kind, sui generis laws के लिए कंट्री में बने. Then copyright act इंडिया में बहुत पहले से था. Patent act तो हमारा 1800 something का था, which was revised in 19 something, and finally 1970 का जो हमारा act था वो बहुत अच्छा माना जाता है उस समय के हिसाब से. बट उसमें यही था कि स्ट्रेटेजाइजेशन था ड्यूरेशंस का. फील्ड ऑफ स्टडीज के हिसाब से आपका ड्यूरेशन था कि फूड में 7 साल, इसमें 8 साल, इसमें 10 साल, इसमें 20 साल. तो अब सब क्या हो गया, 20 years स्टैटिक. सो दिस इज द पैनोरामा। अब हम थोड़ा थोड़ा स्पेसिफिक बात करेंगे। अब तक कोई डाउट? नींद आ रही, डाउट कहाँ आएगा ना, राइट। सो ये कुछ एग्जांपल्स हैं, आप लोग यदि पहचान पाए ये क्या है। स्पेशल लॉजिकल टॉय वाज द पेटेंट, इट इज रूबिक्स क्यूब। बोर्ड गेम apparatus was the patent, मोनोपोली लिखा ही है उसमें। सिस्टम एंड मेथड फॉर फिलिंग कंटेनर्स विथ फ्लूइड्स, ये होली का टूल है हमारा, राइट। होली पे हम लोग बलून इसी से आजकल काफी बच्चे यूज करते हैं। बारबी डॉल। सो यदि हम डेफिनेशन की बात करें तो a right granted to inventors to prevent unauthorized usage। अब इसमें ध्यान दीजिएगा कि नेगेटिव राइट है, पेटेंट इज नॉट अ positive right. Why? Because it does not put any onus on you to practice your patent. Once you get it, you have a monopoly of a particular time, provided you are paying the fees for maintaining the patent, but you can forbid or prohibit others from using it. It is like your property. आपको कार नहीं चलानी है, खड़ी रखेंगे आप, जब तक आपकी आप नहीं चलाएंगे, बट कोई आपकी कार लेके तो नहीं जा सकता। तो सिमिलरली इन दैट सेंस पेटेंट इज अ नेगेटिव। हालांकि इंडिया में कुछ है रूल, फॉर्म 27 एक लगता है आपको हर साल, यूटिलिटी यूसेज ऑफ पेटेंट लिखना पड़ता है, बट दैट डजंट अफेक्ट योर पेटेंट राइट्स। यू हैव टू जस्ट इन्फॉर्म वेदर इट इज वर्किंग और नॉट वर्किंग। So for an invention within a particular territory for a limited time, so limited time monopoly hai in a particular territory, does not guarantee freedom to exploit the invention। इसका क्या मतलब हो सकता है? does not guarantee freedom to exploit the invention। कोई थोड़ा सा आइडिया लगाएगा? नींद कम होगी। मतलब बेसिकली बात यह है कि आपका पेटेंट होने से ये नहीं हो जाता कि आप मार्केट में प्रोडक्ट बेच सकते हो। क्यों? क्योंकि आपका पेटेंट जब हो सकता है, जब आप प्रैक्टिस करोगे तो इट इन्फ्रिंजेस अदर्स पेटेंट्स। जैसे बल्ब है, हम सब क्या जानते हैं बल्ब किसने इन्वेंट किया? थॉमस अल्वा एडिसन ने। बट एक्चुअली व्हाट ही इन्वेंटेड वाज द टंगस्टन फिलामेंट। ऑल अदर वेयर द इन्वेंशंस ऑफ अदर्स। ऐसा शेप होना चाहिए, नोबल गैस भरना चाहिए, फ्लैंज स्ट्रक्चर होना चाहिए। सो ही फर्स्ट टुक लाइसेंसेस ऑफ ऑल दोस फ्रॉम ऑल दोस पीपल, एंड देन using his tungsten filament he was able to offer a product in the market, right। negative right है, territorial है, limited time 20 years from the date of application। ये ट्रिप्स के बाद आया, ट्रिप्स के पहले अलग अलग था इंडिया में और वर्ल्ड में अलग अलग। positive right restricted by the previous patents, or freedom to operate, market or practice you have to judge or see। so patent is a contract between the government and the pupil। These are the requirements of patentability। यदि आप देखेंगे तो patentability के दो realm of requirements हैं। One is substantial requirements and one is the procedural requirements। procedural requirement, आपको यदि कॉलेज में एडमिशन लेना है तो ये फॉर्म भरना है, लेटेस्ट फोटो छपवानी है, नीचे नाम लिखा होना चाहिए और डेट ऑफ बर्थ लिखी होना चाहिए, डेट ऑफ फोटोग्राफ लिखा होना चाहिए। फॉर्म 1 भरो, फॉर्म 1 में आपका नाम, आपके इंस्टीट्यूशन का नाम, आपके असाइनी का नाम, ब्ला 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 ब्ला, जो भी है वो सब यहां कवर होगा। दूसरा, इसमें इनेबलमेंट का एक क्लॉज होता है, डेफिनेटनेस और बेस्ट मोड। ये तीन आपको कहानी में बताने हैं। बेसिकली दो चीजें होती हैं किसी पेटेंट डॉक्यूमेंट में, वन इज द क्लेम्स एंड वन इज द बैकग्राउंड स्टोरी। अब बैकग्राउंड स्टोरी में आपको सब कुछ लिखना है, बट उसको एंश्योर करना है कि आप उसको क्लेम में भी कवर करें। यदि कोई चीज आपने कहानी में लिख दी और क्लेम में कवर्ड नहीं है तो वो क्या है? वो पब्लिक है। दैट इज, इफ इट इज नॉट पार्ट ऑफ योर क्लेम्स, वो आपको उस पर कोई राइट मिलने वाला नहीं है, वो आपने पब्लिक पूल को और एनरिच कर दिया अपनी कहानी के थ्रू। बट आपकी कहानी में आपने इनेबलमेंट कि कोई दूसरा आपके डॉक्यूमेंट को पढ़ के आपके पेटेंट को प्रैक्टिस कर पाए, डेफिनेटनेस होनी चाहिए एक ही इन्वेंशन के रास्ते पे, ये नहीं कि देन यदि आपको मल्टीपल चाहिए तो पेटेंट ऑफ एडिशंस या इंडिपेंडेंट पेटेंट्स का है। एंड बेस्ट मोड आपको बताना है भाई आपके पेटेंट को प्रैक्टिस करने के लिए क्या बेस्ट मोड है। मान लो ये पर्टिकुलर प्रोडक्ट बनाना है तो इस पर्टिकुलर प्रोडक्ट का जो बेस्ट परफॉर्मेंस है वो किस तरह के इंग्रेडिएंट से आएगा, वो आपको एग्जांपल्स में देना होता है। सब्सटेंटिव रिक्वायरमेंट है, पहली चीज तो पेटेंटेबल सब्जेक्ट मैटर होना चाहिए। व्हाट डज इट मीन? इन एवरी एक्ट देयर इज अ सेक्शन 3 इन इंडियन एक्ट सेक्शन 3 है, उसमें क्या क्या पेटेंट नहीं हो सकता ये लिस्टेड है. सो व्हाटएवर इज लिस्टेड देयर, बियॉन्ड दैट एवरीथिंग इज पेटेंटेबल. तो लिस्टेड क्या क्या है, यदि हम उसको एग्जांपल के तौर पे देखें तो एक इंपॉर्टेंट है आर्टिकल 3D इंडियन एक्ट. 3D क्या कहता है, एवरग्रीनिंग ऑफ पेटेंट्स को रोकता है कि जब तक ये जो फार्मा इंडस्ट्री है वो स्मार्ट है. फार्मा इंडस्ट्री क्या करती है, एक ड्रग लाई, जब उसका पेटेंट खत्म होने वाला हुआ उसके चारों तरफ एक नई बाढ़ क्रिएट करती है. वो तो मर गया बट एक नई बाढ़ ऑफ पेटेंट्स चारों तरफ एक नई बाउंड्री बना दी, एंड अगेन एक और नई बाउंड्री बना दी. अब लॉ के स्टूडेंट्स यदि हो जो भी, तो जस्टिन अयंगार का एक जजमेंट था जिसके बेसिस पे आर्टिकल 3D एक्ट का पार्ट बना, और इसको लेके जो यूएस और इंडिया ट्रेड नेगोशिएशंस का बहुत बड़ा फ्लैशिंग पॉइंट है ये कई बार आर्टिकल 3D, बिकॉज मोस्टली फार्मा इंडस्ट्री इज यूएस एंड यूरोप बेस्ड. देन ऐसी मशीन बना दूं जो ऑक्सीजन बर्न कर दे, पेटेंट मिलेगा, बिकॉज इट इज कॉन्ट्ररी टू द नेचुरल ऑर्डर. इस तरह की चीजें जो है वो नॉन पेटेंटेबल है. उसके अलावा जो हमने पेटेंट की जो टाइप ऑफ आईपीस पढ़े, ट्रेडमार्क, कॉपीराइट, ब्ला ब्ला ब्ला, उन सब के भी डोमेन की जो चीजें हैं वो पेटेंटेबल नहीं होती, क्योंकि वो आपको फिर नहीं तो देयर विल बी ए प्रॉब्लम. देन नॉवेल्टी क्या होता है, व्हाट इज नॉवेल्टी, नया होना चाहिए. मैं एग्जांपल से बताऊंगा वैसे कि नॉवेल्टी एग्जैक्टली क्या मीन करते हैं, बट बेसिकली नया होना चाहिए. नया इन द सेंस उसमें बहुत नया होने की जरूरत नहीं है, जरा सा भी नया हुआ होगा तो वो आपका उतना आपका नया है. 99% पेटेंट जो एप्लीकेशंस नॉवेल्टी पे नहीं मरते हैं. किस पे मरते हैं, नॉन ऑब्वियसनेस. व्हाट इज नॉन ऑब्वियसनेस, इट शुड नॉट बी ऑब्वियस टू अ पर्सन स्किल्ड इन द आर्ट. फॉर एग्जांपल, इफ इट इज अबाउट कारपेंट्री, something which is obvious to a carpenter is no. And non-obviousness also grows over the time. For us as kids, mobile was a wonder. For you as kids, mobile was okay. For kids now, it's more than obvious. For a 1-year-old kid also is able to play with the touch screen mobile very easily and comfortably. So that evolves with time. And utility is again a loose requirement. It should be capable of industrial use, what it is said about. एक एग्जांपल है, एक टेबल है जिसका टॉप जो है स्क्वायर, राइट, और हमने एक इन्वेंशन बनाया जिसका टॉप जो है हमने राउंड कर दिया. सो इज दिस इन्वेंशन नोबल? यस, इट इज नोबल. टॉप जो है वो कैसा है, आप केवल इतना याद रखो कि ये स्क्वायर, बस यही आपको पता है, जो प्रायर आर्ट मैंने दिया है वही पता है. सो क्या ये नोबल है? यस, इट इज नोबल. बट क्या ये ऑब्वियस है? नॉन ऑब्वियसनेस पे ये फेल हो जाएगा, क्योंकि कारपेंटर के लिए आम बात है कि वो चौकोर बना दे या गोल बना दे. नाउ दिस इज द इन्वेंशन 2. ओनली रिमेंबर द प्रायर आर्ट 1. सो नाउ हियर इफ यू सी, he has replaced 4 legs with a single leg, and this is something which is not obvious even for a carpenter. So उस लाइट में ये जो है पेटेंट जो है ये नोबल भी हो जाएगा और नॉन ऑब्वियस भी हो जाएगा. अब लेकिन ये देखो, अगेन दिस हैज ए सर्कुलर टॉप. नाउ वी आर एडिंग प्रायर आर्ट 2, चेयर. उसी तरह का एक सिंगल बेस है और 4 फ्लैंज स्ट्रक्चर सिंगल लेग पे बना दिया. अब क्या सोचते हैं, यदि हम पीछे चलें उस वाले सेकंड वाले एग्जांपल पे, तो क्या हमारी जो टेबल है सिंगल लेग वाली वो नोबल तो रहेगी? ऑब्वियसनेस अभी खत्म हुई कि नहीं हुई? अभी नहीं होगी. क्यों? क्योंकि यहाँ अगेन एप्लीकेशन डिफरेंट है. टेबल इज फॉर कीपिंग थिंग्स, whereas chair is for sitting. So in that sense, still our invention is noble and non-obvious. Other forms of IP की बात करें, copyright and related rights, I have already told you, it is about expression of idea. So it is a more loose type of IP. You easily get it. It is just a registration. There is no substantive examination. Lawyers आपको registration नहीं भी कराना तो दूसरे तरीके भी बताते हैं. आपको यदि अपना कोई थीसिस है या कोई वैसे करना है, कॉपीराइट रजिस्ट्रेशन नहीं कराना, आप अपने ही पते पे उसको स्पीड पोस्ट में बंद करो और अपने ही एड्रेस पे वापस भेजो और उसी स्पीड पोस्ट को आप वैसा का वैसा पैक्ड अपने पास रख लो. Whenever there is a question of your authorship, you can put that closed envelope in the court of law for as a proof. So that is one way which is available. Then copyright is available for life plus 50 years. In India it is around life plus 60 years. Reason, कभी गीतांजलि का पेटेंट खत्म, कॉपीराइट खत्म हो रहा था तो गवर्नमेंट ऑफ इंडिया ने विश्व भारती को 10 साल और ऐड करने के चक्कर में उसको 60 साल कर दिया है. Performers right and phonograms right, around 50 years they are. So if you want to have really golden songs, वो आपको कई बार कॉपीराइट फ्री मिल जाएंगे जो 50 साल से ज्यादा पुराने हो गए. ट्रेडमार्क इज बेसिकली a goodwill between the company and the customer. यदि कोई इस तरह का लोगो बना है तो ऑब्वियस है कि ये प्रोडक्ट अच्छी क्वालिटी का होगा, इस प्रोडक्ट में खराब चीजें नहीं यूज की गई होंगी, ब्ला ब्ला ब्ला. एंड कस्टमर इज ऑल्सो रेडी टू, या देयर कैन बी एम्प्टीन थिंग, and the customer is also ready to pay extra special price for that goodwill. So that is what it is. GI की बात करें, graphical indications जो हैं, इससे पहले जो IP की टर्म होता था that used to be appellations of origin. So when GI came in, champagne किस वाइन को आप बोल सकते हैं? फ्रांस का शैंपेन रीजन में जो पैदा हुआ अंगूर है उससे बनी हुई वाइन को ही आप शैंपेन बोल सकते हैं. सो हो क्या रहा था, इंडिया को कैसे बेनिफिट मिला? हम चंदेरी का एग्जांपल लें. चंदेरी साड़ीज एक समय पे चंदेरी से ज्यादा बनारस सूरत में बनने लगी. वो जो आर्टिसंस थे, वो जो स्किल पर्सन्स थे जिन्होंने हंड्रेड्स ऑफ इयर्स जनरेशन टू जनरेशन लगा के जो स्पेशलाइजेशन पाया था, that specialization was being wasted and the material. तो अब GI आने के बाद क्या हुआ, केवल उस ज्योग्राफिकल रीजन में जो साड़ी बनेगी उसी को आप ऐसे GI टैग चंदेरी के साथ बेच सकते हो. अभी आपने ये स्कीम सुनी होंगी, वन डिस्ट्रिक्ट वन प्रोडक्ट सुना है, ODOP या वन डिस्ट्रिक्ट वन स्टेशन, वन स्टेशन वन प्रोडक्ट. ये भी सब जेनेसिस GI से ही है. यदि आप मेरी ये जैकेट देखेंगे, ये भी एक ODOP प्रोडक्ट, इसको कहते हैं बदरवास जैकेट. ये शिवपुरी डिस्ट्रिक्ट का ODOP प्रोडक्ट है. बदरवास जैकेट इज द ODOP ऑफ शिवपुरी. सो इस तरह से भी जो लोकल आर्टिशंस हैं उनको काफी इंपटस गवर्नमेंट की तरफ से इस तरह की आईपीस के साथ मिल रहा है. हालांकि हमारे यहाँ तो चलता रहा है, ये पहले से है. ग्वालियर की चाट, ग्वालियर में कौन सी मिलेगी? आगरा की फेमस. और यहां से नीचे जाओगे तो सब जगह ग्वालियर का. सो दैट रीजनल वाज देयर और कॉमन लॉ में उसका प्रोविजंस थे पहले भी, बट दे वर रिस्ट्रिक्टेड टू द रीजन वेयर यू वर नोन. बट अब इस आईपी के साथ आपका जो स्केल है वो काफी ज्यादा बढ़ गया. इंडस्ट्रियल डिजाइन सिंपल है, इसको लूजली डिजाइन पेटेंट भी बोलते हैं. लूज टर्म्स में क्या बोल देते हैं इसको? डिजाइन पेटेंट. अभी आप देखोगे तो कई लोग आप बोलेंगे मेरे 50 पेटेंट, बट मोस्टली दे आर रजिस्ट्रेशंस. सो डिजाइन रजिस्ट्रेशन इज एक्चुअली जस्ट अ रजिस्ट्रेशन. इसका कोई फॉर्मेटिव एग्जामिनेशन नहीं होता और इसमें कोई फंक्शनैलिटी पे आपको कोई राइट नहीं मिलता. जस्ट बाय द बेयर आई व्हाट यू सी इज योर राइट. इसका लगभग 15 साल का प्रोटेक्शन है, इसीलिए आप देखते हैं हर 2-5 साल में एक नया रेन आ जाता है, बिकॉज दैट पैकेट इज डिजाइन रजिस्टर्ड. अब कुछ कीवर्ड्स पे बात कर लेते हैं एंड देन आई थिंक इट्स सफिशिएंट. सो आईपी के फील्ड में कुछ कीवर्ड्स हैं जिन पे मैं 2 मिनट लगाना चाहूंगा. वन इज नेशनल ट्रीटमेंट. व्हाट डू यू अंडरस्टैंड बाय नेशनल ट्रीटमेंट? ये ट्रिप्स के फीचर्स हैं बेसिकली. So national treatment is, आप कहीं भी टूरिस्ट प्लेस पे गए होंगे, entry for Indians 15 rupees, for foreigners 500 rupees. That is not allowed in the realm of IP after trips. जो फीस आप फॉरेनर से लेंगे वही फीस आप इंडियन से लेंगे. इंडिपेंडेंस ऑफ एप्लीकेशन का क्या मतलब है? आई टोल्ड यू दैट पेटेंट इज अ सोवरेन राइट. So if I file a patent in 7 countries, all the 7 jurisdictions will examine my patent independently, and rejection in one jurisdiction will in no way impact my patentability in other 6 jurisdictions. Everywhere it will be examined independently. However, there is a mechanism called patent highway. India, I think, has been signatory recently. Till now, only 5 countries were the signatories. They used to share their search reports. Whatever search report Japanese patent office had, they used to share with the US patent office or whomsoever were the part of the patent highway. The benefit was, but still, examination was independent. Even after sharing the search report, it was very possible that the patent was granted in a second country and rejected in one country.
PCT only for exemption. PCT.
PCT is this. I'm coming to world patent. So most favored nation. This is another thing which has come up with TRIPS. India is free to give any favor to any country. The only catch is that it automatically applies to everyone else. So if you give most favored nation to status to any country, you give certain relaxations to any country, those are applicable automatically to all other WTO countries. There is no thing called world patent. World patent is a misnomer. The only mechanism available is PCT, Patent Cooperation Treaty. What it gives you is an extra 30 months of time span to ensure and to judge how commercially viable your patent is. And on that basis, you decide to invest further in the countries wherein your particular application, you find some interest or some commercial value. So it will give you 30-month time span. You will analyze the inquiries and all those things. And on that basis, when the time of national phase entry comes in, you can decide whether you want to go for national phase in those countries or not. Again, it is also further structured. If you go to EP, EP is again an umbrella, or a repo is again an umbrella. Then individual countries, if you want, you can go. बासमती पेटेंट एंड हल्दी पेटेंट किसने सुना है? सो बासमती पेटेंट यूएस में हुआ था. एक चावल का वैरायटी था टेक्स्टमती. सो टेक्स्टमती वैरायटी का एक क्लेम था रिलेटेड टू इट्स अरोमा, एंड हैड दैट क्लेम बीन अलाइव, all the exports of basmati from India, Pakistan and Bangladesh would have infringed the patent of Textmati. CSIR on behalf of Indian government fought this case, and finally what we did, Textmati patent may be still today, but that particular claim on aroma was deleted, and hence our basmati stopped infringing the claim. Haldi was about, there was an Indian called Diamond Chakravarti. He basically patented the medicinal use of haldi in US. And had then that been not revoked, all those exports from India of traditional medicines like Vico products, they would have been infringing the haldi patent of Diamond Chakravarti. Now, compulsory licensing is, any idea? What is compulsory licensing? Patent is a monopoly. However, if the government feels that for a certain thing it is mandatory for the life of the pupil or for any other reason for the life of the country, licenses is to be provided to others beyond the permission of the patent holder. The government can, but the government has to fix some royalty for the original patent holder, and then it can be licensed to other persons so that the production, यदि ऐसा लगता है कि कोई दवाई की बहुत जरूरत है और वो ओरिजिनल पेटेंट होल्डर के पास इतना प्रोडक्शन कैपेसिटी नहीं है कि वो बना के जो करंट पेशेंट्स हैं उनकी जरूरत को पूरा कर पाए, then that case government can issue compulsory licenses. SCPs and friend licensing, ये टेलीकम्युनिकेशन इंडस्ट्री का प्रोडक्ट बेसिकली एस्पेक्ट है. टेलीकम्युनिकेशन इंडस्ट्री जब ग्रो कर रही थी तो सबसे पहले टेलीफोन्स कहां बने? यूएसए, बेल लैब्स. So this Ericsson couple had a shop in Norway or somewhere in the Baltic Europe. Now, Mr. Ericsson went to US to find what is the status of telephone. And when he went there, he found that telephony is just restricted to the walls of knowledge about telephony is just restricted to the walls of the company which was making the telephones. Nobody in US beyond those contours knew about telephony. He wrote a letter from there to his wife, who also was a technician, that if telecommunication industry has to become omnipotent or it has to be found everywhere, it should be standardized. And since then, the telecommunication industry works on these standard essential patents and friend licensing. Every bundle of generation of telephony, 1G, 2G, 3G, 4G, 5G, now probably 6G will come. Those are basically bundles of patents of various companies and entities. They all bundle their technologies in a single generation and then license to everybody who is ready to pay a definite friendly licensing fee. So in that terms, SEPs and friend licensing is working. Challenges की बात करें तो AI, अभी कल ही मैं न्यूज़पेपर में पढ़ रहा था, some news agency has sued an AI search engine for using its content without the copyright permission. Then legal hurdles, enforcement is a problem. Indian acts, still you will find a lot of Nikes and all those, any local market you go, lot of branded products with those logos you find, and there is no infringement proceedings.
No check and balance.
Yeah. Then time. Usually the students की बात करें तो patent जब वो करने चलते हैं, so patent takes around 48 months if you are not paying the express fee. Then your focus is on publications, because in PhD, if you are doing PhD, you have to have publications, and if you publish, you can't patent, and if you go for patent, it takes a lot of time. Even in CCR internally, we take around 6 to 8 months to go there, and then so there is always a sort of game between what to do, what to patent or to publish. And then enforcement and global competition. So a lot of competition has come in and you have to cope up with it. As far as opportunities are concerned, I gave you an example of Bhadrawas jacket, global recognition you get for your products, and certain products have Frido. If you see, Frido makes those shoe soles and all those things. Those were small SMEs and they've reached some to an inflection point. Uniform legal framework is an opportunity. You have uniform law with TRIPS. Growing pool of knowledge, it can be a gold mine. As an industrialist, if you want to produce something which is not protected in India, you have a huge market, you find something in US patent database, you manufacture it, nobody is stopping you. Until and unless you are not exporting to the country where it is protected. Gold mine of information, and then market access. So with that standardization, tying it with business, you also get, not only you have to open your markets, you also get a lot of market access. These are some of the good sources of knowledge. Spicy IP is a very good site. I think whomsoever is interested in IP should at least read its weekly review every week. And wealth.wipo.int is a good source. There are a lot of courses of WIPO e-learning academy which you can register. So with this, I think I'm at the end. So I thank you for your kind attention. It was really tough for you.
Thank you so much, sir, for sharing your invaluable insights and enriching our understanding. Students are requested to please settle down. We now request the Honorable Pro-Vice Chancellor Research to kindly present the token of gratitude to our esteemed speaker, Dr. Sandeep Singh. Sir, please. We are extremely delighted to welcome our esteemed speaker, Dr. Rishi Sharma, Principal Scientist, CEERI, Pilani, for gracing this event with his presence. I request the Honorable Pro Vice Chancellor Research to kindly welcome Dr. Sharma with a salutation. So please. It is my privilege to introduce our eminent speaker, Dr. Rishi Sharma, an accomplished scientist and researcher in the field of electronics and nanobiosensors. Dr. Sharma obtained his MSc and PhD in electronics from Jawahar University, Gwalior. He has been a recipient of prestigious research fellowships from both the University Grant Commission, New Delhi, and the Defense Research and Development Organization, India. Dr. Sharma has significantly contributed to the development of organic materials-based detection system for toxic agents, showcasing his expertise in applied research and societal impact. Currently, Sir is working as a scientist in the Nano Biosensors Group at CSIR CERI, Penang, where his research focuses on the design and development of advanced chemical and biological sensors. We warmly invite Dr. Sharma to deliver his lecture. Sir, please.
First of all, I would like to give my sincere thanks to the organizers and for inviting me and giving me opportunity to discuss about the IPR. I'm not like expert in the area of IPR, but we are working in the field of semiconductor fabrication, and I'm particularly working for the development of microsensors. So since Dr. Sandeep has already covered majority of topics related to the IPR, so I'm not going into details of all those things, which may be boring for all of you. But let me touch few points which are pertinent. That is one thing why you want to go for patent. Another thing is when the startup culture is growing in India, why it is important, because some of you can go and can establish any startup. So This is about the searching the databases, and when we begin, it is my feeling that we should give sincere thanks to the scholars who have worked in the areas of science and technology. So whatever we are doing these days, it is actually we are standing on the shoulders of our great leaders. So there are points like discovery, invention, creativity, and innovation. These are the terms which are important, but I'm not going into detail to it. That what is discovery, what is invention, what is creativity, and what is the innovation. But these all points are important as far as if we want to look for IPR. This is one example, a flow chart, which is indicating why you want to go for IPR. Suppose we have developed, say, microsystem. You guys have developed some microsystem, and you go to some conference and presented that microsystem to your friends and peer groups, and you came back from that conference, and later on you go for patent, and when you file the patent, you realize that someone has already copied that idea and they have taken patent. So the monetary benefits of that IPR cannot be taken up because you have not done the patent. Broadly, classification of IPR, as Dr. Sandeep has already covered, it's copyright, patent, trademark, arts, performance arts, databases, or design rights. So I'm not going to about the trips, as he has already covered about trips. So I'm skipping these all slides. But one slide which I usually present is about the discovery of Raman spectroscopy. That how the conventional setups can also give discoveries. So sometimes people say that you need a very great laboratory facility to establish or develop something. This is one example with small setup he has discovered about the Raman spectroscopy. So these are some of the applications on which that small but vital discovery is now one of the very important tool for research and development. It is very important for the pharmaceutical areas as well as for semiconductor, for forensic areas, and this all. This is another conventional setup for X-ray diffraction. As you can see, this is very basic setup. But this basic setup is whatever discovery about the XRD. Now, this setup is very well used among the semiconductor areas for the characterization of materials. So this is an example that very basic setup can also lead to discovery and lead to some patents. This is example of innovation. Discovery is something which is already there and you are just adding to it. But when we talk about innovation, this one example that how the creation of you can say the aircraft. This is the journey which is showing here. The Wright brothers. So I'm just skipping these slides. I come to this point like good practices. Whenever any researcher they are working, some of the good practices one has to follow. And if someone is looking for patentability, then the creation of lab notes becomes very, very important and very, very vital. So when any IPR infringement or somewhere you have to fight for the IPR cases, one has to understand that the laboratory notebook and the creation of laboratory notebook, there are certain set of procedures which one should follow in labs. These are some of the points like how a laboratory notebook should be prepared. And some of the companies, they used to take the carbon copies of whatever daily notes you are taking, and they're countersigned by the head HODs or some independent experts also, so that they can fight if any of the uh, information got leaked into the system. So these are some example I have taken from the research paper, that laboratory notebook should be have hard bound, should have the book number, year, and the dedicated person who is using that. So these are some of the examples, and how you are going to note down all those notebooks, date, pattern. Some countries like month and year are interchanged, month and date are interchanged. So the standard protocol would be like, I have to write like today's date, the month, August, 29th August 2025. This should be the standard protocol. Somewhere when you have to strike out or you have written something wrong, there are certain procedures that you have to follow. So these are some examples. Now when seven sins of when we do research, the wealthy without work, pleasure without consciousness, science without humanity, knowledge without character, politics without principles, commerce without morality, worship without sacrifice. These are some of the points which a researcher should at least follow. So ethics is very, very important in research. Whenever you are writing any article, you should fair enough, and you should not hide facts, because that will be a crime. When you hide facts in scientific discoveries which lead to the failure later on. So hiding the facts. So for a researcher who has a thought for creating patents and new ideas, so ethics should be the highest peak. There are many points within the ethics, but I'm just skipping them. Plagiarism is one of the most important thing for researchers. Falsification, fabrication, fraud, non-compliance to the regulatory guidelines, inappropriate authorship, withholding the data manipulation, right? So these are some of the things comes under work ethics. Since I am working in the area of semiconductor, so these days, like one point Dr. Singhai has already covered, that is about the integrated circuits. Their IPR are patentable. Normally, when we fabricate any device, we used to have layout designs, because in semiconductor processes, various stages one follows for the realization of the devices, active devices or passive devices, like for that matter, like transistors. So, in case of integrated circuits, we used to patent the layout design, and because that will safeguard uh, the IP. because one can do reverse engineering and can understand what type of fabrication process flow you have adopted and what type of mask layout you have used. So normally companies, if they are going for the patent, they go for the patenting of the layout design. That is photo mask also. Now, artificial intelligence and how that artificial intelligence based IPR which are coming up. So these are the challenges, and these days the laws are coming up, they are not yet framed appropriately. That if someone use AI to generate idea, so there are points like for patentability in India, the person should be present. So there are some challenges, and the countries they are working, because AI is using the databases available across the sectors, across the scientific domain. And when we use the algorithms and simulate them, and we generate some images, some ideas using already existing IPRs. So the work is going on, that how to patent something which is generated by using AI. So this is one area where people are going for patent using the power of AI. So in a way, it is misusing the AI. So that is one of the points. So with this point, I just give thanks to all of you to listen to me. And questions if you have.
Thank you, sir, for such an enlightening session on intellectual property rights, challenges and opportunities. We now request the Honorable Pro Vice Chancellor of Research to kindly present the token of gratitude to our esteemed speaker, Dr. Rishi Sharma. Sir, please. Thank you, sir. Proceeding further, we are privileged to invite a distinguished scientist and academician, Professor Dr. M.B. Kaushik, Pro Vice Chancellor of Research, Amity University, Madhya Pradesh. With a remarkable career at Defence Research and Development Establishment, Government of India, where he retired as Director and Outstanding Scientist, Dr. Kaushik has represented India globally and has been honored with prestigious awards like the DRDO Scientist of the Year, the Agni Award for Self-Reliance, to name a few. So we now request you to kindly share your concluding remarks with us.
Good afternoon to all of you. And have the patience, I'm not going to take more time. Okay. Dr. Sandeep from MP Bhopal, Dr. Rishi from CSI or Siri Pilani, Dr. Pankaj Mishra, Dr. Rai, all head of the departments, and my dear students. At the outset, I'd like to thank my senior colleagues over here, the friends, those who have come from the CSI organization and talked about the challenges, opportunities, and challenges in intellectual property right. You have been listening this talk for the last 2 days. I'm going to give you 2 examples, live examples, I think, which you will be able to understand and will be able to appreciate the significance of the IPR, why at all IPR should be taken. And one important aspect which I want to tell you, all of you are students. You would not have come to that stage of, or would not have understood thoroughly that what are the implications of the IPR. And it is not only the domain of the intellectuals or those who are scientists or social scientists. The patent can be taken by anybody, or the copyright can be taken. It is the idea which is very important. So it means all of you have the capability and the capacity to develop something, to have the idea, to materialize it, and then take the patent on your name. So it's not new that only the scientists or the researchers or the technocrats only have got the right to take the patent and copyright. 20 years back, in one of my interview, this question was asked. What is the difference between patent and a publication? This was a question asked when I was appearing in UPSC, one of the exam, for my the selection as a scientist. UPSC. This question was came. He says, I was a researcher. So they asked me a question, how many papers you have published? So I told, okay, so many papers have been published. He says, how many patents? I also told about the patent also, that 2 or 3 patents. That time I developed that. So I told that. He says, what is the basic difference? And to be very honest, it took me some time to explain the basic difference between publication and patent at that point of time. But later on, I realized, no doubt, the answer was given by the panel members there itself. I told, as far as publications are concerned, both of them, they generate new knowledge. But what the publication is doing, it's of more of academic interest. But that academic publication or academic interest can also develop the resources, or it can be also be patentable at a later stage. Once you publish, then take the patent also. However, the basic difference lies, which I think all of you should remember, the patent have got the commercial value, the publication do not have the commercial value. So this is what's mote torped, the difference can be told, that patent have got the commercial value, publication do not have the commercial value. Now, when we talked about this, so we developed about the, and moreover, once the product is developed, it does not mean that you cannot take patent on that. Whatever just was told by Dr. Sandeep as well as Dr. Rishi Sharma, any incremental improvement in the process, if you are developing process, that is also patentable. One product have, or one process have n number of patents also. But only thing is, there should be some novelty or some improvement has to be there on the existing knowledge. That is what called the innovation is. Invention is something new altogether from scratch, which has not been established earlier, where the innovation is that any incremental improvement on the existing knowledge will result in the form of innovation. Okay, this is one thing. Now, for example, I'll give the 2-deoxyglucose, 2-DG, which was very common during COVID. That when the oxygen supply was not there, so this was developed by Reddy's laboratory. No doubt, it was developed at DRD Gwalior, where I was also one of the member of developing the technology. 2DG was already documented in the literature. It was known as a product. ग्लूकोज जो रहता है उसमें हमने एक ऑक्सीजन कम कर दिया तो इसलिए 2-deoxyglucose हो गया. That is what is the molecular formula. But what was happening is the process which was reported in the literature was very costly, lengthy. 7-step method was there. So we reduced it to 2-step method or 3-step method, and the yield was of the purity was also improved. We took a patent. So the patent was also given to us. After that only the Dr. Reddy's laboratory took the license from us, which I myself gave the presentation. I'll tell you what is the importance of the purity. Whatever was reported in the literature, it was 96-97% pure. Okay. So whatever the methodology of the process we developed at Gwalior here itself, we claimed it at 99% pure. And you'll be surprised to know, when I was myself was giving a presentation to Dr. Reddy's laboratory 25 years back, I was full of confidence because whatever was reported in the international market was approximately 1 lakh rupees a kg. And our product was approximately 20,000 to 30,000 rupees a kg was the cost, which we were trying to bring it. That cost was reduced, purity was improved, process was changed, and we went for the technology transfer to Dr. Reddy's laboratory. When I was giving a presentation, so I was thinking that I have achieved something great. No doubt patent has also been taken because I could protect my intellectual property right by taking a patent. However, when we were transferring the technology, you have to give complete information to the industry so that they should develop this product in large quantities for the public at large. So it means you have to be open. You can't make it secret at that particular point of time. When I was giving a PowerPoint presentation like this, whatever we are giving, So I was talking with a lot of overconfident and says, this is what we have achieved. We have reduced the cost. So much of the foreign currency will also be saved, and we are the first one to develop that one. And there will be 20 people resting in the conference hall where I was giving the presentation. Everybody was keeping quiet. And then one question which was asked finally, he says, all perfectly all right. The technology is very good. Product, whatever you have developed is very good. It is have a lot of the potential as an anti-cancer agent, because that was whatever we develop as an anti-cancer agent, later on it was developed for the coronavirus also. And then what they asked me, no, you are claiming the purity of this one, 2-deoxyglucose or 2-DG, as 99% pure. We are not interested in 99% purity. We are interested in what is 1%. You will be surprised to know, I was taken aback and I was shocked because I was not having an answer to that. I was talking about 19 because we are thinking in one direction. He says, no, 99% is okay, but we are interested in what is the 1%? I told the impurity. He says, what is the impurity profile? We are going to check this particular compound on human beings, not on animals. So even 1% can bring about the mortality and can bring about the adverse physiological change. So that's why 1% is important. And you'll be surprised to know, I had to work, came back and then worked for 6 months to find out what is 1% impurity in our process, because it was a process patent, not a product patent, because product was already reported in the literature, on which it was not possible for us to take the product patent, but process patent we took it. So similarly, it takes time. If that much improvement you can take the patent, that's what I'm telling you, that all of you have got the capability to make a marked change in the existing technology, existing devices, either process or product. You can take the patent. I'm not going to talk about copyright, trademark, design, industrial design. These are the things, or the GI tags. So patent I'm just referring to. Similarly, now another question which is of view of debate, whether the AI or machine learning assisted development of any product, whether we can take the patent or not on the basis of AI or machine learning. This has come up very well in the case of now pharma industries, that new product, new drug, new vaccine are being developed with the help of AI or the computational chemistry or the computational chemistry. One thing I want to tell you, the product which you are developing, the new product with the help of AI and machine learning, the AI process and machine learning process cannot be patented. However, the new product which you are developing with the help of AI assisted or machine learning, to the best of my knowledge as of today, the product, only new product will be patentable, not the process, because AI and machine learning has been what he was talking as obvious technology. There is known that the AI and machine learning will do the job that is expected of, just like what are the example he gave of tables and chairs, and then what is expected of a carpenter. So some of the things I to the best of my knowledge, some more knowledge may come into being, that will be very important. And then what Dr. Rishi Sharma told, this is the most recent topic of semiconductors. On the Prime Minister was talking from the Lal Killa, Red Fort, that okay, we are going to go into the semiconductor technology, and the first chip which is going to be manufactured in India, which are going to be used in your computers or mobile phones or anywhere else, it will become indigenous. As of now, all the chips or the IC circuits we are importing from outside, because the semiconductor technology is not available in our country, and no other country is ready to transfer the technology or to knowledge to India. So it means we are going to generate our own knowledge, and then the fab facilities, the fabrication facilities, which is he is also working on it, and then the chances. So it will be novelty. It will be something new which is going to come. Similarly, I'll tell you one more example, because all of you are listening very patiently and attentively. So I can give one more chance, take chance one of that. What has happened is, 2 herbalists in Assam, Dhimaji place, across Brahmaputra, they were not educated, they were not graduate, they were not students. The traditional knowledge, they were having the traditional knowledge with the help of a plant variety, which he mentioned. That okay, plant varieties, something plant is new, which has not been documented in the Botanical Survey of India or by the herbarium available in botany. That is, if not known, then you can definitely say, okay, you can take the patent or you can mark it that way. But the plant product, if it's something new, it can be patentable. So I was given a chance. Okay, one of the my own senior scientist gave me a powder, and he says this powder have got a anti-malaria efficacy. which is better than that of any drug or any medicine available in the market. So will it be possible to find out what exactly this one? A common thinking was, he gave me, I put that same the bottle on the shelf of a laboratory, thinking that okay, ये क्या जादू टोना की होगा, क्या पाउडर से निकालेंगे, क्या करेंगे, and just kept it and never bothered कि anything happen. तो बाद में सस्पेक्ट भी किया, तो जो आदमी ने जो पाउडर दे रहा है वो हमें बेवकूफ बना रहा होगा, इसमें क्लोरोक्विन की टैबलेट मिक्स करके पाउडर बना के कुछ तो भी देता होगा, and then he is doing that business. But my boss, my teacher, my mentor, my supervisor, and whatever I am today is because of him. He was pure scientific. He did not leave me. He says, what has happened? Every week he used to ask me, Dr. Kaushik, what has happened to that powder which you have? Do you have analyzed it? So by compulsion, I started doing that because there was no option, because the boss is boss. So and when he's asking, so I have to be answerable to that. But honesty and sincerity has to be there in researchers. You cannot just bluff him on the basis of that, okay, if you don't do it, and then tell him, okay, isme kuch nahi hai. That sorts of thing cannot happen, because he himself will start doing himself. That was the way he taught me. So I started working on it. We came out that something new is there in that compound, in the two. And when we investigated, he says, okay, perfect, I am not going to believe this powder, which I have got it from some other source, from unknown source. Somebody picked up the bottle, gave it to me. I said, no, I want to have the genesis or the originality of this powder. So I had to go to Tezpur. From Tezpur, I took another the gypsy, crossed Brahmaputra on a now, because Brahmaputra तो full चल रहा था बारिश के दिनों में. So we across, and then we met two herbalists. जो herbalist in the जो पत्तों पेड़ पौधों की जानकारी उनको रखते हैं. Okay, दोनों की अलग-अलग दुकानें चल रही थी. दोनों शाम को बैठते थे, and then उनके घरों के सामने लंबी-लंबी कतार लगी हुई थी. और उसमें से एक जिस हर्बलिस्ट के पास पहले मैं गया, उसके पास उसके इवन उन दोनों लाल बत्ती की कार हुआ करती थी, जो एसपी या डीएसपी या कलेक्टर के पास होती थी. तो वहां एक कार भी खड़ी थी. मैंने पूछा, ये कार किसकी खड़ी, लाल बत्ती वाली कौन खड़ा है? डॉक्टर के हर्बलिस्ट के पास आया है ट्रीटमेंट के लिए. तो उन्होंने कहा कि एसपी की मदर आई हुई है, उसको भी ट्रीटमेंट चाहिए. मींस एमडी एमएस डॉक्टर दे आर सिटिंग आइडल, एंड दे ऑल द पेशेंट्स वर गोइंग टू द हर्बलिस्ट टू टेक द एंटी मलेरियल ड्रग, मलेरिया की ड्रग वहां लेने के लिए उसको लाइन लगी हुई थी. एनीवे आई वेंट ओवर देयर. छोटी सी उसका घर था, स्टोव चल रहा था, स्टोव पे भगोनी थी पानी की, उसमें पत्ते डले हुए थे, वो उसमें कंटिन्यूसली उबल रहे थे, और बाकी उसके ड्राई पाउडर भी उसके शेल्फ में अलग लगे हुए थे, हरे पत्ते उसके पास थे. मैं वहां बैठ के ऑब्जर्व करता रहा उसको, वो दवाई देता रहा. जब उसके सारे पेशेंट खत्म हो गए, सो आई सेड, आई हैव कम टू यू, आई वांट टू नो कि ये पत्ते कहाँ से लाए, चलिए मेरे साथ जंगल में. मैं उसके साथ जंगल में गया. उसने कहा ये पेड़ होते हैं, अरुणाचल पास था, धेमाजी अक्रॉस आसाम में. हमने वहां से कुछ पत्ते इकट्ठे किए, 5-6 किलो लेके आए. उसके बाद पूछा, आप करते क्या है, और व्हाट इज द प्रोसेस. तो उसने कहा कि प्रोसेस ये है कि मैं इनको बोलता हूँ, एक गिलास पानी लेता हूँ, उसको कंटिन्यूस उबालते उबालते उसको आधा कप कर लेता हूँ. आधा करने में 3 डोज बनती हैं, और इसको 3 डोज देने से यदि कोई भी मलेरिया से तकलीफ है, परेशानी है, 3 डोज के साथ उसको मलेरिया हमेशा के लिए खत्म हो जाएगा, जब तक कि मॉस्किटो उसको दोबारा बाइट ना करे. यदि पहली दफा बाइट किया और उसको मलेरिया हो गया है, तो 3 डोज में ठीक हो जाएगा. एंड विच आई इंटरव्यूड सम ऑफ द पीपल, यस. उसके बाद हमें, जबकि वहां पे मॉस्किटो इन्फेक्टेड एरिया मींस मैक्सिमम मॉस्किटोज वहां मिलते हैं बारिश के दिनों में, और लोग मरते हैं तो मलेरिया से मरते हैं. Malaria and filariae, they are the two type of disease are there where maximum mortalities is because of malaria. But these people are saying, claiming that way. I says, okay, fine. Then we did a lot of investigation in the laboratory, in the Gwalior itself, where in my own laboratory, and then identified new molecule which was not reported in the literature. That is called gomphostinin. Gomphostinin, we have given the name. It was because of gomphostinin navium and gomphostinin creatinine. These are the two plants were there, and both the plants were having anti-malarial properties. We investigated it thoroughly, did the characterization, and we applied for patent. We did some biological studies also, and you'll be surprised that question in between which I was asking to Dr. Sandeep about the PCT. Okay, so national, हमने immediately national patent लिया उस पे, और national patent लेने के बाद हमने PCT अप्लाई किया for friendly countries. And one particular patent, international patent, what we normally call as in the language, 29 countries we got the protection. In the sense, it was registered in 29 countries, that particular patent. वो पेटेंट 19 कंट्रीज में हमारे अपने नाम से हमने लिया. दैट इज नॉट मोर इम्पोर्टेंट. व्हाट आई वांट टू टेल यू राइट नाउ ओवर हियर, उस हर्बलिस्ट का नाम भी पेटेंट में वन ऑफ द मेंबर था. We gave him that, which he was having. So patent means the gentleman also, because the knowledge was shared by him. He only created the knowledge. No doubt the source was there. The biochemical characterization, we did that, identification of the compound we identified, but he was also the source of information. So that meant the individual, the acknowledgement in terms of giving him the authorship is also very much required. So any idea comes to your mind, anybody, so that is need to be protected and need to be acknowledged. उसका नाम देना है. यदि किसी ने आइडिया दिया तो आपको उसको acknowledge करना है. अभी कल एक मेरे पास एक एग्जांपल आया. Exactly, एक स्टूडेंट ने something he developed in Malaysia, and that was regarding some diabetic. Okay, and then the opportunity was given that some of the students were called in Germany to pitch the new ideas. कि आपके पास कोई भी नया आइडिया है, हम आपको प्लेटफॉर्म दे रहे हैं, आप ऑपरेट करते हैं, आपको आके उसके बारे में बोलना है, बताना है और पिच करना है. नाउ शी इन्वेस्टिगेटेड एंड उसका जो प्रोजेक्ट था वो अप्रूव हो गया जर्मनी में. एंड देन उसको टीएडी देंगे, ये करेंगे, फलाना, उसको स्पॉन्सर कर दिया, सब चीज हो गया. बट अल्टीमेटली द गर्ल फाइनली व्हेन द टिकट आ गया, वीजा हो गया, शी रिफ्यूज्ड. आई एम टॉकिंग अबाउट मलेशिया, जर्मनी में इस टाइप का आइडिया था. Then he says, भाई क्यों मना कर रहे हैं? बिकॉज मलेशिया वाइस चांसलर कहने लगा, हमने आपको भी इतना खर्च किया, इतना प्रोटेक्शन दिया, बिकॉज यूनिवर्सिटी वाज इंटरेस्टेड कि हमारी यूनिवर्सिटी के नाम भी होगा, इसने एक पिच आइडिया किया है. बट दैट वाज नॉट ओरिजिनली हिज आइडिया. आइडिया वाज ऑफ हिज फ्रेंड. उस लड़की की जो फ्रेंड थी उसका आइडिया था. उसका आइडिया भी नहीं था, उसके फादर का आइडिया था. तो उसके फादर ने उसको बताया तो उसने उसको आइडिया ले लिया. बट शी वाज स्मार्ट एनफ to convert into that of a pitch and claiming as if this is her contribution. Later on, दोनों में झगड़ा हो गया, conflict हो गया, and nobody went over there, and उसका अभी तक किसी ने पेटेंट भी नहीं लिया. So sometimes what has happened is, so original, the idea has to be given. I'll tell you, I was also working, one more example I'll take it. Bhopal accident, the methyl isocyanate accident which took place, which has the casualties of large number of people, and Madhya Pradesh में तो खास तौर से that is the most industrial accident हुआ था. और संदीप वहीं से बिलोंग करते, वहीं से आ रहे. तो right now, so he can appreciate that what kind of a tragedy was there. I was given the responsibility that okay, you have to synthesize methyl isocyanate in the laboratory because we want to test against rats. Rats पे देखना है कि ह्यूमन बीइंग जो इतने लोग मरे हैं तो उसका मैकेनिज्म क्या, उसकी दवाई क्या है जिससे हम बाकी लोगों को बचा सकें. That was the target on that day, when the 3rd of December 1984, when this casualty happened. So large number of people died, and large number of people became handicapped. Large number of ladies, those who were pregnant, they had the deformity of child. So you know, it was a huge crisis was there. And then I was also not very aware of. Nothing was, not much of information was available about that particular compound, the methyl isocyanate. And then I was searching here and there, and it took me at least 15 days, 20 days, 30 months, and then pressure was so much on from the government of India, for my own organization, that I have to give the methyl isocyanate as quickly as possible. And you know, all my test methods, whatever I was trying, I used to do 2 experiments, 3 experiments, 4 experiments per day, and all the experiments by the end of the day used to fail. So failure is not a failure. Failure is a path to success. This is what the story I want to tell you. So I think for 10 days, 15 days, I was unsuccessful. So I was, you know, desperate. What to do, what not to do. ये भी fail हो गया, ये लगाया तो ये fail हो गया, ये लगाया तो ये fail हो गया. So all सारे ideas got exhausted. Whatever I could think of and whatever the information I could get it from the literature. Then one of my colleague, Dr. Pandey, no doubt he is no more nowadays because he died during COVID. He asked me, he said, Dr. Kaushik, could you synthesize? Could you get it? तो मैंने कहा सब कुछ नहीं मिल रहा, मैंने ये ट्राई किया, मैंने ये ट्राई किया, मैंने ये ट्राई किया, कुछ नहीं मिल रहा. He was working on some of the catalyst. He says, why don't you try phase transfer catalyst? And you'll be surprised to know that only worked. You know, that idea was given him by him that you try, why don't you try this? It worked. And after that, we synthesized methyl isocyanate, we become the pioneer. We could establish that what kind of a drug should be developed against the patient, those who are suffering from methyl isocyanate. And we gave him, no doubt we did not take the patent because compound was already known in the literature, but we published that paper And in published paper, we gave his name also, the gentleman who told him, why didn't you try for staff secretary? So, that much honesty and sincerity should be there in terms of development of whether you are taking the patent or any new knowledge which you are generating. I'll not take much time. Thank you very much. I'll thank once again. Thank you.
Thank you, sir, for your profound remarks. We now request the co-convener of this national workshop, Professor Dr. Swapnil Rai, Associate Dean Research at Amity University, Madhya Pradesh, for a vote of thanks. Sir, please.
Very good afternoon to one and all present here. It is an honor and privilege to propose a vote of thanks on behalf of the organizing committee of the National Workshop on IPR, Opportunities and Challenges, organized by the Directorate of Research and Publications from 28th to 29th August 2025. First and foremost, I would like to thank to Honorable Founder President Dr. Ashok K. Chauhan sir, Chancellor Dr. Asim Chauhan sir, Pro Chancellor Lieutenant General V.K. Sharma sir, Honorable Vice Chancellor Professor R.S. Tomar, and Pro Vice Chancellor Research Dr. M.P. Kaushik sir, having faith on us, in myself and Dr. Pankaj Mishra and the team for organizing this workshop. And thankful to I extend my thanks to Dr. Sandeep Singhai, Senior Principal Scientist, CSIR, AMPRI, and Dr. Rishi Sharma, Principal Scientist, CD Pilani, for gracing us and their valuable lecture, which definitely very insightful and provide they covered the theme of this workshop. I'm also grateful to the head of the administrative IT and for their full cooperation in for the successful conduction of this workshop. I'm also thankful to Team ESCO for their support for videography and photography, and Mr. Suraj Niboria for the media coverage. I would extend my heartfelt thanks to all the members of organizing committee, starting with Professor Dr. Pankaj Mishra, who is the convener of the workshop, Dr. Madhvi Tomar from ASFDT, Dr. Neha Sharma from AIB, Ms. Swati Mehra from ALS, Dr. Manish Dubey from ESCO, Dr. Shalini Pathak from AIB, Dr. Narendra Kumar Garg, Dr. C.S. Raghuvanshi, Dr. Ritu Kumari, and Dr. Deepak Motwani of ASSET. Special thanks to Dr. Vishakha Mandal and Ms. Anvesha Singh for their excellent comparing and timely management of the changes as and when required. We are also grateful to all the administrative and support staff for their continuous assistance, which played a crucial role in the successful conduction of this program. On behalf of the Directorate of Research and Publication, I once again thanks all the participants and everyone for their presence and contribution for making this workshop a success. We look forward for more enhancing programs in the future. Thank you so much.
Thank you, sir. With this, we come to the conclusion of today's session. On behalf of Amity University, Madhya Pradesh, we extend heartfelt thanks to all the distinguished speakers, session chairs, participants, and organizing members who made this event a great success. Thank you and have a great day ahead.
ये सर उसका पॉइंटर का